us today is State versus Marrow. And the judges have read the briefs, we're prepared to hear oral argument, just a couple instructions or caveats before we begin. First of all, please stand behind the lectern there because we are video recording this for our YouTube channel. And please keep your voice up because of that. And then I would remind everyone not to use the names of any victims or of any minors. Okay, and you each have 15 minutes apiece. And you can reserve, as you know, but you're not usually an appellate, so
No.
so I'll remind you. You can reserve up to 5 minutes.
Thank you. May it please the court, Kevin DiMartino on behalf of the state of Ohio, the appellant in this case, we are asking that this court reverse the trial court's decision denying the state's request for a continuance of the suppression hearing and simultaneously granting the defendant's motion for suppression based on the state being unable to present any evidence because the continuance wasn't granted. The standard of review in this case is an abuse of discretion, which is analyzed under the Unger factors. In this case, Mr. Marrow was out on bond. He had occupational driving privileges. He had moved the court to suppress evidence. A hearing was scheduled for December 20th. That hearing had to be continued because the state was unavailable due to the prosecutor being in another trial on that date. So it was rescheduled from December 20th until January 17th. On January 17th, when the hearing was scheduled to begin, the prosecutor advised the court that it was forced to seek a continuance because the state trooper, who was the sole witness for the OVI charge, had not appeared. The prosecutor indicated to the court that he had issued a subpoena, that he was surprised when the trooper didn't appear, that he had made phone calls, he had sent an email, he had even called down to the trooper's supervisor to try to figure out where the state trooper was.
The appellate's brief says there isn't anything on the docket about a subpoena.
Right. So I'm glad you brought that up. So with regard to subpoenas, Criminal Rule 17 allows the state prosecutor to serve a subpoena. That would not go through the court. In fact, in our office, we typically, don't subpoena officers, but when we do it through Matrix, which is our court system. So not every subpoena has to be on the docket to exist, and the proper place to have challenged that would, of course, have been at the trial court level because it's now forfeited. If they had challenged the prosecutor saying, I issued a subpoena, and if they had challenged the court saying that the state is not pursuing contempt on that validly issued subpoena, so the court's statement shows that the court believed it had been issued, and the court further stated that the prosecutor had engaged in due diligence by making all those phone calls. But all of that could have been stated below, and then we would have had it in the record before us. So there is certainly no...
Well, the prosecuting attorney down below didn't attempt to proffer the subpoena and say, look, here's the subpoena I sent.
No, because it wasn't questioned. The court even said, at this time, part of the reason I'm not granting the continuance is because you are not seeking contempt on a properly served subpoena. So there was no issue, no reason for anyone at the trial court level to say, oh, someone's going to challenge whether a subpoena was issued. Not everything, especially subpoenas, appear on the docket because we can do those through the mail. We can do a letter through the mail. So if the court is doing the subpoena, serving the subpoena, it will show up on the docket. But they do not all show up on the docket. And even if a court-issued subpoena is done, sometimes things don't appear on the docket, which is why you have to raise that at the trial court below. There's no way to get it in the record. Here, there's no reason to disbelieve the prosecutor's statement and the judge's statement during the hearing that there was a subpoena that was issued. It's really improper to just make an assertion that says something along the lines of, I'm not questioning the credibility of that prosecutor when you actually are. There's no citation to any law, any case, any statute that says if a subpoena doesn't appear on a docket, it doesn't exist. In this case, you can tell by the prosecutor's statements, the judge's conversation with the prosecutor, there was no belief at the trial court level that the subpoena was not done. And it's kind of improper for me to ask you to take, judicial notice of the fact that I can't really ask you to take, which is that not everything that happens is on the docket. All I can cite to is an actual rule, the criminal rule that allows prosecutors to serve that subpoena. Yes, in theory, a return should be done, but a return not being done is not dispositive of whether a subpoena was sent. But more importantly, it doesn't matter whether the officer was subpoenaed, because the court didn't engage in the Unger factors. If a validly issued subpoena was dispositive of whether a continuance should or should not be granted, there would have been testimony about that, but it's not one of those factors. Even if you argue it's under the other category, here there was no dispute, no doubt, no allegation that there was no subpoena done. This prosecutor clearly expected the trooper to arrive and had engaged in every effort he could think of to try to find out where the trooper was. We couldn't even show in the record how long of the continuance the prosecutor was seeking because the court didn't give the prosecutor time or the opportunity to ask that. So even if we say the court was proper to consider the fact that the state didn't seek contempt, which that is not a fair basis and not an Unger factor either. At the time, the prosecutor had no idea where the trooper was. So we can't make a decision about whether or not to pursue contempt. We don't know if the officer was willfully missing court or if the officer was sick, was in another proceeding, was involved in some law enforcement business, was stuck in traffic. No one knew where the officer was. So the timeline of what a continuance would have been would not have been very long. If that's clear from the record, we just needed the officer to get there to figure out where he was, if he was sick, if he was injured, if he could get there later that day, in the next couple of days. It certainly would not have been a long continuance that was sought. That is one of the Unger factors. Other continuances, the only continuance the state had asked for was when the state was in another trial and clearly could not be in two places at once, and that resulted in about a 3-week delay in a Zoom hearing that was occurring for a defendant who was out and who had occupational privileges. Inconvenience to the litigants, there's no evidence in the record of any inconvenience to the litigants. Certainly the state wasn't arguing any type of inconvenience. The defense didn't argue any inconvenience, and it's important to remember this defendant wasn't even quote-unquote inconvenienced by coming to court. It was a Zoom hearing. So there is no evidence in the record. I don't need to speculate about it because nothing was put into the record. The reason...
Well, the attorney below mentioned he was under driving restriction. That would be some inconvenience to him while the case is pending.
While the case is pending, but that would have happened whether, in the interim of resolving...
There was some inconvenience to him. It doesn't make it sound like the defendant was just living scot-free, if you will. He had responsibilities. He had to make this case pending, and your party didn't show.
Right.
It had no excuse for not showing. He didn't contact, if somebody's properly subpoenaed, he's an officer, he could have contacted the prosecutor and said, I can't make it, here's why.
Right.
In fact, your person below called his supervisor who didn't know where he was.
Absolutely. We were trying to figure out where he was.
So you would think if it was some accident or illness, his supervisor would know why he wasn't at work.
And
There was nothing there. There was no effort by anybody to find out what was going on that was successful.
There was no successful effort.
Very little done before him. This wasn't something that occurred, so we're speculating as to maybe something terrible happened, or maybe he just didn't get the message and didn't know. And the prosecutor below didn't follow up with that well enough to make sure we knew what was going on.
So the record, part of the appellant's brief where they tried to say nothing was done before and this shows a lack of diligence, all of the information that's in the record with regard to the prosecutor's conversations trying to reach the trooper relate to that day. So there's no evidence in the record that this prosecutor had not already met with the trooper, that the trooper didn't know the date.
That's because the prosecutor didn't put that on the record. The prosecutor had the opportunity to put on the record whatever the prosecutor wanted.
Right, but that wasn't...
Didn't say that.
I
so we should speculate it did happen?
No, but what I'm saying is, the only thing that is at issue right now is the reason for the continuance. The continuance was being sought because the trooper was not there. So at the time, the prosecutor put on the evidence of, here's my witness, he's supposed to be here, he's not here, I don't know why. So how much prep they did before that isn't really relevant to why isn't the trooper here right now. The prosecutor clearly did not know why. If there had been an accident, and it is all speculation because it's not in the record, there's no reason to believe that that trooper would have called the supervisor and said, I'm at the side of the road, or I'm in the back of an ambulance and I'm not going to make this hearing. I agree more could have been done, that there could have been some contact, but it did not happen. And that happens frequently at the trial court level. Things happen. I mean, people get stuck in other hearings. They're in another court. Lots of things cause people to be delayed, which is why we were asking for a continuance to find out what is going on with the trooper. The court did not engage in the analysis. The fact of the matter remains, yes, the trooper could have called the court, the trooper could have called the prosecutor. The prosecutor did everything that they could, including calling the supervisor. I don't know how much more of a burden we can put on the state when they're asking for a continuance when their only witness doesn't show up. Even the court found that that prosecutor needed due diligence to try to get that trooper there that day.
Did the trial court make it a continuance contingent on the state instigating contempt proceedings? Was that part of it?
It was part of her basis.
Contingent, or was that just something that she had said on the record?
It's one of the things she said on the record, and I have that in here.
And you're in your 5 minutes.
Yeah.
If you want to continue.
Yeah, I'll continue. But that is part of what she said, in basically not granting the continuance was because the state was not pursuing a contempt on a validly, it's on page 9 of my brief, the absence of an indication by the state to file immediately contempt against the trooper for refusing to appear for a validly served subpoena is what the court stated.
So it sounds like she would have granted a continuance had you have done that?
Maybe.
Yeah,
It's not clear, to be honest. What is clear to me is that there was not an analysis of the Unger factors. That is not, and it's a separate issue, the state would argue that is not a proper basis. That's not a recognized Unger factor, and it would be improper to put the state in a position where if you go ahead and pursue a contempt right now, maybe I'll give you a continuance. Well, I can't in good faith pursue a contempt against an officer if, God forbid, there was an accident. I don't know what happens because it's not in the record. And I'm not going to speculate, and I'm not asking this court to speculate either. I am asking this court, though, to recognize that the criminal rules allow the prosecutor to serve subpoenas, and that would not show up on the docket. And there is no reason in this case to believe that the prosecutor was incorrect in his assertion, and that the court was incorrect in her assertion, which she believed to the degree that it had been served, that she made the comment about you should be basically pursuing a contempt if you want that. So it would be improper to now find, when it wasn't raised below and has now been forfeited, that there's evidence there was no subpoena that's not there.
Counsel, in regard to the Unger factors, I want to make sure I understand your position in regard to that. Are you submitting to the court that the court has to do a weighing on the record or in the judgment entry, or do we presume the court did consider the Unger factors?
I would argue that if it is not in the journal entry or the transcript, the court cannot presume that the Unger factors were followed. I have argued in other cases that even though the court didn't say Unger and did not articulate every factor, that it's clear from the record that those factors were considered. In this case, the record is devoid of any indication, in my opinion, that the court considered the Unger factors. The court looked like it considered the fact that the trooper did not appear, we did not pursue contempt, and based on that, we have presented no evidence, which is not in the journal entry either. The journal entry, when you look at that, granting the motion to suppress, it looks like the prosecutor showed up for a hearing with no evidence or didn't know how to present evidence or something like that. It is very misleading, in my opinion, as to what actually occurred that day. A short continuance, at least to have figured out what was going on, why the trooper was not there, could have been enough time to allow the state certainly to get the trooper there or to come back to the court and say, here's what happened, here's why I'm asking for a continuance, but instead it was unilaterally denied. And based on that, the state would respectfully ask that this court reverse the trial court's decision and remand.
Thank you. You're at 145.
Thank you.
147. For rebuttal. Good morning.
Thank you. May it please the court, Kimberly Stout-Shearer on behalf of Jameire Marrow. It is our position that the trial court did not abuse its discretion with granting that motion. With motion to suppress at the end, actually, by denying that motion to continue. We believe throughout all this that the trial court did apply those factors. They didn't specifically outline that within their journal entries.
Well, did they outline it on the record?
They did talk about it with it because there was a discussion of where the trooper was. At no point did the state offer indication as to how long they needed, what they needed, or where they were. All the evidence that was provided and all that the state provided was that they tried to contact that trooper that morning, were unable to locate that trooper, had followed up with their supervisors, and had no idea where that trooper was.
Under factors, length of delay requested, did the court talk about that?
They did not with it. There was discussion throughout it of where they knew the trooper was. And at that point, they had indicated repeatedly that they did not know where the trooper was.
And
They
did,
had no indication where he was.
right. And did the court talk about previous continuances?
Previous continuances, there have been the discussions of it, there have been the prior continuance, and that was part of the reason why they were denying it at this point.
Okay, so the court did talk about on the
That
record.
there had been one prior continuance.
Okay. Inconvenience to the parties?
The defense had indicated that there had been, in reference to, and I apologize, I'm just looking, on, counsel had objected, the defense counsel had objected to it because that had been ongoing, and that Mr. Marrow had been under driving restrictions and had been under those restrictions throughout that. That's on the
So,
transcript of page 3 and 4 of the
okay,
transcript.
so the defense counsel objected to the continuance?
Correct,
And said, these are the reasons why I'm objecting, and so.
correct.
Did the court further inquire about that?
They did not further inquire beyond that.
Okay. All right, you may proceed.
Thank you, Your Honor. Moving on to factor number 4, as to whether or not that delay was for legitimate reasons or whether it was dilatory, purposeful, or contrived. There's nothing in the record, and I don't believe at this point, there's nothing in the record that the state is doing anything intentionally or did anything of that nature. We just had a witness that realistically didn't show. And at that point, at what point do we keep continuing hearings, keep continuing when we have no response from the supervisor, when supervisors can't respond as to where he is? We have no trooper that's there. The state's indicating that there is a valid subpoena and things with that. I understand with it that the state may issue those separately without putting them on the docket. There's been no discussion, or there was nothing that was even proffered as to what the date was that subpoena was sent to them.
But on the other hand, the defense attorney didn't object or, call to the court's attention that there was no subpoena issued. It seemed like everybody acquiesced that the subpoena was issued, just for some reason the officer or the trooper wasn't in court.
And I understand, and I concede to that. The defense did not raise that. But there seems to be a disconnect as to where that trooper is throughout all this. At no point was there any officer, was that officer provided. There was no indication that the supervisor was locating him. There was no indication that the supervisor or another officer was coming in his place. It was constantly that prosecutor that was present at that time in the state of Ohio was that they could not locate anyone, nor could their supervisor locate him in order to specify why he wasn't there or how much of a delay they would need. The state of Ohio has said, well, we don't know if he was sick, we don't know if he was in an accident or something like that. At that point, we're in some conjecture and making guesses as to where he is. We don't know. It could have been he was at home sleeping. At that point, we have no idea. Or just blatantly ignored something that was for the court.
Well, that's what I was just going to ask you, but there was no indication either that he intentionally didn't show up.
There was not. There was not any indication one way or another. It was just a matter of that his supervisors could not even locate him, which typically is unusual
That's what I was going to say, yes.
with that.
So there were unusual circumstances, but.
Yes, I do concede with that that was unusual circumstances, because typically you were able, as you go through the chain of command, someone is able to provide some response, but we have a trooper that did not even respond in any way, shape, or form. Factor number 5 is whether or not the defendant contributed to that circumstances. It is clear that Mr. Marrow did not contribute to that. Mr. Marrow was present that day. He was there. He was logged in, ready to go, and ready to proceed.
was he calling any witnesses, or any witnesses subpoenaed by the defense?
No, there were not. The only witness that was scheduled for that day was a trooper. And finally, factor number 6, which is any other relevant factors that depend on that unique facts of the case. This is rather broad, because we were very limited in that scope when they did the transcript, because it was strictly in that hearing was whether that trooper showed, why wasn't he there? And if there was any reason why he wasn't there. The state at no indication and no point offered any evidence or offered any testimony as to what due diligence they had made to contact that trooper prior to that day. They didn't offer anything into the record. There was nothing offered. Everything was revolved around strictly that morning.
Well, the subpoena too, because subpoena was issued.
Yes, but any contact with, there was nothing that was offered in the record that indicated that the state had any communication with that trooper prior to, or even attempted to have that communication with that trooper prior to that morning. To know
Did
whether,
anybody ask any questions about that?
unfortunately, no. That was not indicated. What the trial court had indicated there was at some point and had made conjecture about filing the contempt charges. And it doesn't seem, and it doesn't appear from the way the journal entry indicates, is that she hinged her decision solely on them refusing or intending to file contempt charges. It was an indication that if something is valid, the state of Ohio has the ability, if they so choose, to file that contempt.
Counsel, I want to make sure, in the journal entry itself, the court doesn't even deny the continuance, right? It doesn't even talk about the continuance. Maybe I think my case is mixed up.
They indicated at that point
That the state wasn't prepared, didn't have anything to offer.
that they were not prepared at that point, that there was no witnesses.
Okay, so the court did say, I deny the continuance because blah, blah, blah.
They did not in the journal entry. That was just strictly on the record and in the transcript. That part.
Thank you.
On the record, the state never states they're not going to file contempt. As I recall, there was no inquiry about that. The court just kind of, if you will, left to the conclusion, well, you're not going to file contempt. And view that as some form of a factor of whether continuance could be granted. Is that fair?
That is fair with it. There was no indication one way or another from either party as to what was the status of that or whether or not they were going to file a contempt of non-witness. It's left for us to make assumptions, which at this stage we cannot make those assumptions as to whether the state was to file that contempt or not. Based off of that hearing and the subsequent journal entry, we believe that the trial court did apply those factors. We don't believe that they specifically outlined them and said specifically, these are the under factors, 1, 2, 3, 4, 5, 6, but I believe based on their analysis and based on the discussions that were on the record, that they did properly apply those factors. We are asking at this point then for this honorable court to please affirm the trial court's decision of January 17, 2023, ruling that denied State of Ohio's motion to continue and granted Mr. Marrow's motion to suppress. Thank you.
And you have 1 minute and 47 seconds left.
Thank you, Your Honor. I just would like to point out, the prosecutor did state on page 2 of the transcript that the subpoena was sent out on December 28th, which is about 3 weeks before the hearing. So there is evidence on the record of the date that the subpoena was set. I believe the opposing counsel said that.
Any evidence, other evidence on the record of attempts by the prosecutor to talk to this witness before the hearing?
Not before the hearing, but the court did ask and note in her, when she was talking to the parties, the diligence that the prosecutor took on that day to find the trooper, which makes sense. If you've been talking with, and I'm not asking you to engage in speculation, just saying, that you can look at it both ways. If I'm expecting my witness to come, I'm not gonna say, I've been talking to this person for days and days. It was clear that that prosecutor was surprised the trooper wasn't there and had made phone calls and sent emails and mentioned the subpoena. And if we have issues.
And I'm just speculating, I'm just asking, does the record say, in between the subpoena and the trial date, there were emails and phone calls made?
No. But also, if we've issued a subpoena and there's nothing in the record to refute that, what more should we have to put on the record? A subpoena should be a sufficient way to have a witness appear. It would be unfair, in my opinion, to have the state also show, well, I had a subpoena issued 3 weeks before the hearing, and then every 24 hours, every 3 days, every 5 days, I said, hey, remember that subpoena? I mean, there is in the record evidence of the subpoena. When you read the way the trial court spoke in the hearing, it was, well, based on no indication that the state is at this time immediately going to pursue a contempt on a validly served subpoena. That is not if it was validly served. She said validly served subpoena. There's nothing in the record here to challenge that there was a validly served subpoena. And it would be unfair to put a further burden on the state when we are showing that there was a subpoena, or indicating that there's a subpoena. No one is challenging that subpoena to then say, well, we don't think the prosecutor was diligent. Thank you, and I would just ask the court a person remand.
Thank you both for your presentations to the court. The court will take a matter under advisement, as you both know, and will issue a written opinion. Well, the clerk of courts will issue a written opinion that we've sent to both sides, and also we release them on the Ohio Supreme Court website over time. So thank you so much.